Hello and welcome to today's live webinar with Matthews Folbigg Lawyers. Great to have your company. I'm Daniel Kim, your host, and today's topic is navigating the icebergs of the Australian consumer law, risk management for business. It's a really important topic in the Australian business landscape, but it's not one that everyone is entirely familiar with, which is why I'm joined live in the studio by a couple of experienced commercial lawyers from Matthews Folbigg Lawyers, Philip Brophy and Douglas Brown. Gentlemen, welcome.
Thank you.
Great to be here, Daniel.
Yes, thanks very much. It's great to have you presenting on this webinar because it's a really important topic, Phil. It applies to every service and good that's sold in the country.
It does, yes. It's got quite a broad coverage.
Yes, and also the word consumer might be a bit misleading, Douglas, but it applies to B2B companies just as much.
Yeah, exactly. The unfair contract terms legislation applies to business-to-business contracts, also misleading and deceptive conduct and unconscionable conduct that we're going to talk about. That's relevant for all types of businesses.
Yes, clearly lots to cover on today's program. And don't forget, you can join the conversation by clicking the dark blue hand icon at the top of your screen to ask a question, which will come through on this trusty old iPad of ours. And we'll aim to get through as many of those questions at the end of the presentation. If you happen to leave early today, please click the yellow button at the top to provide some feedback before you go. It would mean a lot to us if you did. And it's now time to kick on to today's presentation. So we're talking about the Australian Consumer Law, or ACL for short. It's the Commonwealth legislation which replaced the old Trade Practices Act, and topics we'll cover today include consumer guarantees, express warranties and warranties against defects, unfair contract terms, misleading or deceptive conduct, and unconscionable conduct. Well, Philip, that's a whole lot. Firstly, can you explain to me a bit of the background? Where does it come from?
Yeah, sure, Daniel. They come from the old Trade Practices Act, which was around since 1974. Under that Act, there were implied warranties, in particular that the goods would be of merchantable quality and fit for the purpose. The ACL replaces those implied warranties with what they call consumer guarantees. So those consumer guarantees, which we'll talk about in more detail, apply automatically to all transactions with consumers.
Yeah, I see. And Douglas, what does a consumer mean for these purposes?
Well, the definition of consumer is quite broad. It includes companies, so if a company purchases goods or services, they can be a consumer. There are dollar thresholds here, so basically any goods or services you purchase for $40,000 or less will be considered a consumer transaction. If you purchase any goods or services for greater than $40,000, that can still be a consumer transaction if they're purchased for personal, domestic or household use or consumption. So to give you an example, if you bought a speedboat for $180,000 for your personal use, that would, if it was for personal use, it would be a consumer transaction. If you bought it for your business to hire out, it would not be a consumer transaction.
I see. I wish I was in the position to be able to buy a $180,000 boat every other day. Douglas, so who is bound by these consumer guarantees?
So the supplier of the goods, which is basically the person who sells the goods or supplies the services, like a wholesaler or a retailer. Also the manufacturer, and the definition of manufacturer is also broad. Includes any person or company that puts their brand or logo on the goods. Any person who holds themselves out as the manufacturer, but also, importantly, any person who imports goods into Australia if the actual manufacturer is not based in Australia. So many importing businesses will be considered a manufacturer under the Australian consumer law.
Yeah, I see. Philip, well, can you give us some examples of consumer guarantees?
Yes, Daniel. There are 9 guarantees for goods and 3 for services. Guarantees for goods are very varied. Guarantee as to title, which is pretty self-explanatory. A guarantee that there's no undischarged security interest in those goods, such as a PPSR interest. And these are the 2 critical ones. A guarantee that the goods will be of acceptable quality and fit for any disclosed purpose. Some of the lesser ones, I shouldn't say lesser, but probably less frequently used ones or relied on ones would be a guarantee of correspondence with any sample that the consumer might have been given. Also importantly, a guarantee as to repairs and availability of repairs and spare parts, and a guarantee that the supplier will comply with any express warranty that is given over and above the mandatory warranty.
Gee, that's a pretty comprehensive list there, and you'll see it on your screen at the moment, the list of 9 guarantees. So Phil, you're saying it's the acceptable quality and fit for purpose, they're the 2 biggest ones?
I think they're the important things that any consumer would regard as important. You know, if something breaks down, they don't really care whether they've got good title to it. They just want it to be of good quality.
Yes, I see. And you also said there were some guarantees for services?
Yes. The three of them are guarantee that the services will be provided with due care and skill. That's sort of a concept of negligence. A guarantee that the services are fit for the particular purpose, and a guarantee that they will be provided within a reasonable time.
I see. Now, it does sound a little bit legalistic and legaleasy. Can you explain some of these in a bit more detail for us, please?
Okay, yes. The guarantee of title is that the supplier has the right to sell those goods to the consumer and to pass good legal title to the consumer. Another one, the guarantee of undisturbed possession, that the consumer's possession of those goods will not be disturbed by any other person. An example of that would be if the goods have been sold twice.
Ah, yes, okay.
Yeah, like a used car.
Yeah. Yep.
A guarantee that there's no undisclosed security interest. In other words, they're free from any PPSR interest. That, you know, and that's fairly standard. That you want to get good title.
Yep.
Now they don't apply where it's obvious that the title won't pass. For example, if it's a hire purchase arrangement, or if it's a leasehold arrangement, or if the security interest was created with the consent of the consumer. That's fairly unusual, but it can apply.
I see. Well, thank you very much. Douglas, can you talk us through some of the other guarantees for consumers?
Yes. So Phil said the guarantee of acceptable quality is an important one. That means that the goods or services, the goods that rather are fit for a purpose which those goods are commonly supplied. They're acceptable in appearance and finish. They're free from defects, which is the most important part of this, and they're safe and durable. Now, we're talking about reasonable quality here. So things that we take into account will be like the price, the age of the goods, if they're second-hand goods, and other relevant circumstances, such as representations made by sales staff. But though that guarantee of acceptable quality doesn't apply if any faults in the goods were specifically drawn to the attention of the consumer, if, for example, goods are damaged and they're offered at a discount and that's disclosed to the consumer, that guarantee will be lessened. There's a guarantee of fitness for any disclosed purpose. So a disclosed purpose means anything that the consumer brought to the attention of the seller or the manufacturer or the agent, saying, yeah, this is what I want the goods for. And there's also a representation that the goods will be reasonably fit for any purpose which the supplier warranted that they'd be good for. It doesn't apply when it would be unreasonable for the consumer to rely on those representations, or if the consumer also has some special expertise or skill in this area. So it's more protecting people who are being misled by sales staff. There's a guarantee of correspondence with description. Say you buy something in a catalogue, it matches the description. Also a guarantee of correspondence with any sample or demonstration model. You might buy one good and you purchase 1,000 on the basis of that. So it to be guaranteed that those subsequent 1,000 pieces you purchase will correspond to that sample. There's also a guarantee as to repairs and spare parts, and this is a guarantee given by the manufacturer only, not the supplier, saying that for a reasonable period of time after you purchase the goods, there'll be repair facilities and spare parts available, because you don't want to buy goods if there's no opportunity to get a spare part or get a replacement. It doesn't apply if the consumer is given written notice before the sale that these facilities or parts wouldn't be available. If, for example, it was the last item being manufactured of a good and it was disclosed to the consumer. The last one is a guarantee as to express warranties. So a supplier or manufacturer can give additional warranties in addition to the consumer guarantees, such as a warranty against defects. And this consumer guarantee means if the supplier or manufacturer chooses to give that express warranty, they're guaranteeing they will comply with that warranty.
Yes, I see. So they are the 9 consumer guarantees for products. Philip, you mentioned there were some for services, 3.
Yeah, sure, Daniel. Well, the guarantee of due care and skill is that, as I said, the service provider won't be negligent, and the service will be provided with an acceptable level of skill and or knowledge. That the services will be fit for a particular purpose or to achieve the result that the consumer made known to the supplier. But once again, would not apply if the consumer did not rely on it or it was unreasonable for the consumer to rely on the supplier's skill or judgment. That's an unusual circumstances. Most people rely on the service provider. That's why they go to them. And reasonable time, a guarantee that there will be a supply within a reasonable time. If a time is not specified, then a reasonable time. What is reasonable will depend on the circumstances.
I see. So what happens if a supplier breaches those consumer guarantees?
Well, to look at that, we just need to bear in mind that there are two categories of breaches under the ACL, minor breaches and major breaches. Now, major breach is where the goods or services would not have been bought by a reasonable consumer had they known of the nature and extent of the problem, or where the goods differ significantly from their description or sample, or where the goods or services are substantially unfit for purpose and cannot easily within a reasonable time be repaired to make them fit for purpose, or where they are unsafe. Now, a minor breach is one that is capable of being remedied. Now, if it's a minor breach, the consumer can still require the supplier to remedy the breach within a reasonable period of time by replacing or repairing the goods or resupplying them or refunding the purchase price. Clearly, those lines between a major and a minor failure, it would be, there's not a clear line. There might be some blurring between the two. So if the supplier refuses to comply with a request to remedy a minor failure or fails to comply with the request within a reasonable time, the consumer can reject the goods or terminate the contract or have the problem fixed by another supplier. Now, if it's a major breach, and as I say, the lines are blurred, the consumer can reject the goods or terminate the contract or recover compensation. But clearly the supplier doesn't want to be in that position where there's an argument about whether it's major or minor.
Yes, absolutely.
So now if a consumer rejects the goods, the consumer can elect to receive a refund or replacement goods. If a consumer terminates the contract, the consumer can press for a refund. Hopefully the supplier would be reasonable and provide it without too much further action. Then in the case of services, that might be difficult if the services have already been provided and consumed, as it were. But in whether it's a minor or a major breach, the consumer can still take action to recover damages for any losses suffered, provided those losses were reasonably foreseeable. So that's getting into the areas of consequential losses as to what has happened following the breach.
Right, that's really interesting that there's no clear distinction between the major and minor breach, but it's also good that there's a legal recourse for people when there is.
Very much an area of the facts of the situation.
Yes. Now, Douglas, you also mentioned that manufacturers can sometimes be liable for these breaches. Can you give us some examples of those?
So there are four of the guarantees apply also to manufacturers. They're of goods, of course. They're the guarantee of acceptable quality, the guarantee of supply of goods by description, the guarantee of repairs and spare parts, and of manufacturers' express warranties. Now, a consumer can sue a manufacturer to cover damages, and that can include compensation for any reduction in the purchase price, the value of the goods below the purchase price you paid, and also any reasonably foreseeable loss or damage, as Philip just spoke about. But importantly, a consumer cannot get a repair, replacement, or refund from a manufacturer. They can only recover damages or costs, so just money.
Yes, I see. Now, to be honest, that all sounds rather scary, Philip. Is there any way for a supplier or manufacturer to limit their liability?
Frankly, no, not really, Daniel. The consumer guarantees are mandatory. Their consumers' rights and remedies are mandatory, and the liability, which we'll discuss later, is mandatory. So if you purport to limit those consumer guarantees, that term would be void or unenforceable. So to give a very simple example, if there was a shop there was a sign that said no refunds under any circumstances, that would be void because it would be unenforceable and it would probably be misleading and deceptive, and we'll talk about that later. So without wanting to sound like a lawyer, you can exclude warranties to the fullest extent permitted by the law in your terms of trade, whatever that means. You can limit the range of remedies available to a consumer to replacement or resupply or repair, or paying to have the goods or services repaired or resupplied. But that's still a fairly broad coverage. So I think the message is the supplier's just got to get it right in the first place.
Right. So
save all this hassle.
What Phil is saying is that in all circumstances, a manufacturer or supplier will always be liable.
Not always. I mean, causation is an important issue here. So if the failure of the goods or services to live up to their guarantees was caused by, let's say, the person who purchased the goods, let's say they were damaged after they were delivered to the consumer because the consumer used them improperly, the consumer failed to take reasonable steps to prevent damage, like not maintaining them, the supplier or manufacturer wouldn't be liable in those circumstances. There are also cases where, for example, there was anything beyond the reasonable control of the supplier or manufacturer. Let's say there's the goods or services supplied and there's an environmental disaster, a flood, floods your warehouse. Obviously, a supplier or manufacturer wouldn't be liable there. And also, to claim a refund or compensation, the goods can't have been lost or destroyed or disposed to the consumer. And also, finally, if the failure to comply with the guarantees was disclosed to the consumer beforehand, so as we spoke about, for example, acceptable quality, if you sell goods at a discount and point out the issues with the product, let's say it's a second-hand good, let's say it's damaged already, you wouldn't be liable in that case. So it's really common sense, and we do look at causation. So suppliers and manufacturers won't be liable in cases where it clearly wasn't their fault.
Gee, I'm starting to understand why this is such an important topic for businesses to get their head around. Philip, are there any additional warranties or other promises?
No, the consumer guarantees are fairly extensive. You can choose to give an additional warranty, which is called an express warranty, or in particular you can choose to give a warranty against defects. Now, I frankly think that the consumer guarantees amount to a warranty against defects, so we advise clients not to give additional warranties unless there's some good commercial or marketing reason to do so. Now, just to enlarge on that concept of a warranty against defects, that's a representation made to a consumer that at the time the goods are supplied, the supplier will repair or replace those goods, rectify or resupply the services, or compensate the consumer if the goods are defective. Now, if you choose to give a warranty against defects, it must be in transparent form, must be in a document that is reasonably plain, in plain language, easy to read and presented clearly. Must be concise, not too much other wording around it. State what the consumer must do to claim the warranty and what the business will do if a claim is made, and prominently state that details about who's giving the warranty, what their address is, what their phone number and email address for contact purposes. State any limitation period or during which the warranty must be claimed. Who is liable for the costs involved. State that the warranty is in addition to and does not exclude the mandatory warranty under the ACL. And it must have a mandatory prescribed text that's included in the packaging, and the form of that wording is available on the ACCC website. As I've said, we generally advise clients not to offer warranties over and above the consumer guarantees and to exclude any other warranties, as I say, unless a warranty is negotiated or the business feels there's some reason to go over and above the ACL warranties.
Philip, this is really good because not only are we talking about a potentially difficult or like a negative topic where you need to cover your business risk, if you know the ins and outs, you don't have to give more than you have to. You can protect your business that way.
You use them as a marketing tool. You must comply with them, so why not use them to your advantage?
Yeah, absolutely. Great. All right, so on to a new topic now. Douglas, let's talk about unfair contract terms. What are they and which contracts do they relate to?
So the unfair contract terms provisions, they're also in the Australian consumer law. They apply to standard form consumer contracts and small business contracts. It's very important we set out which contracts these apply to because a lot of people out there think, well, if there's a term in my contract that's unfair, it shouldn't be enforced. Well, they often do. It's important to see which parts of the legislation apply to your particular matter. So we've discussed a consumer contract, it's where the value is less than $40,000 if it's for commercial use. If it's greater than $40,000, it has to be for a personal, domestic or household use or consumption. A small business contract is a new element of the unfair contract terms provisions that was added in 2016. So it only applies to a small business contract that was entered into or renewed on or after 12th of November 2016. Another criteria for it to be a small business contract is that at the time the contract was entered into, at least one of the parties had to employ fewer than 20 people. So they're only trying to capture a small business in terms of both the employee headcount and the third issue I'm going to talk about is the price. So a small business contract is defined as one where the upfront price payable does not exceed $300,000, or if the contract is for more than 12 months, does not exceed $1 million. So it doesn't apply to all contracts. You have to make sure that it satisfies the criteria. Another element is it has to be a standard form contract. So that's basically a contract that is a take it or leave it contract, where you have no opportunity to negotiate, where one party had all the bargaining power and they prepared the contract before you'd even had discussion. So, for example, if you were to sign up a mobile phone contract with Optus, they're not going to carefully negotiate their standard terms. They'll just say, you sign it. If you don't like it, you go to Vodafone. That's an example of a standard form consumer contract.
Right. So
yeah. I mean, the definition of a unfair. What is unfair? There are three criteria. Would it cause significant imbalance in the rights and obligations of the parties? Is it reasonably necessary to protect the legitimate interests of the party? Really, the dominant party that drafted the contract would be advantaged by the term. And thirdly, would it cause detriment to the party that's sort of disadvantaged by the contract if it were to be relied on? Now, the legislation, there are express terms in the legislation that set it out. Do you want to speak about that, Phil?
Well,
yes.
I was just going to say, prematurely interrupted you there.
Sorry, yeah.
I've just got so many thoughts going through my head listening to all these.
Yeah, exactly.
And some of it sounds a bit technical. So, Phil, I was hoping you could take us through some more examples.
Yes, Section 25 of the ACL provides examples of terms which may be unfair. I say may because they are just examples. If it ended up in court, the court would look at the contract as a whole and the surrounding circumstances. So examples of unfair contract terms are a term that permits one party to terminate the contract, a term that enables one party to penalise the other party for a breach or termination of the contract, a term that permits or has the effect of permitting one party to vary the contract or to renew or not to renew the contract. So they're examples that are very much unilateral, where one party has all the power. And it's not unsurprising that those terms would be unfair.
Yeah, it's interesting because sometimes I'm pretty sure I've seen these as a standard,
standard
in inverted commas in other contracts,
Yeah,
and you're telling me these are not fair.
Yeah, they other examples where one party can vary the price, where one party can determine that it's been breached, where one party can assign the contract, or importantly, where they seek to limit the other party's right to sue the party. So, yeah, pretty broad coverage there.
Very broad.
Basically, when it's a one-sided contract, where one party has all the rights and the other party.
Or as lawyers would say, unilateral.
Unilateral. Oh, that sounds very legalese. Right. So, Douglas, you're saying if I have any one of those contracts, any one of those clauses in my contract, it's automatically unfair?
Not automatically. So they were just examples given in the legislation. And as Phil rightly said, the court will look at all the circumstances of how the contract was formed and the bargaining between the parties. It also says in the ACL that if the term is transparent, that will be taken into account. So transparent means if it's expressed in reasonably plain language, it's legible, it's presented clearly, and it's readily available to the party affected by the term. So what they're trying to say is don't bury it in the fine print of your contract in size 6 font where you can't see it. If you prominently display to your customer, these are the terms, that's going to be to your advantage.
I see. So, Philip, what are the consequences of a contract term that's unfair?
Well, the term would be void, and by void we mean unenforceable, but it's important to bear in mind we're not talking about the contract itself, we're talking about the unfair term in that contract, and the contract may be capable of being performed without regard to that term.
Gee, Douglas, I'm imagining these laws would have resulted in many suppliers updating their standard terms.
Well, that's the interesting part. It hasn't.
Oh, really?
I've seen very little change. Most standard contracts you see have very one-sided terms. The issue is, though, currently the government is considering legislation to expand the scope of unfair contract terms. So I discussed it before, it only applies to consumer contracts and small business contracts with a certain value and a certain size of the parties. They're considering making that broader to apply to a greater number of parties. And also they're considering making unfair contract terms unlawful rather than just void. So that would mean that there could be fines imposed on a company if they have it in their contract. Right now it's just void and unenforceable, as Phil said. So there's not as much of a big stick there. But if companies were to be fined for having unfair contract terms in their contracts, I think that would lead to a big change for most companies.
It's typical of some big companies, isn't it? Like, we'll do the bare minimum possible.
Exactly.
If I don't have to change it, I won't,
That's
even though
correct.
it probably is the right thing to do.
Yep.
Okay, so watch this space. Now, on to our next topic, misleading or deceptive conduct. Philip, take it away from here, please.
Yeah, thanks, Daniel. Well, misleading or deceptive conduct was a concept in the old Trade Practices Act, and in the ACL, Section 18 says, and it's fairly similar to the wording in the old Trade Practices Act, a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or is likely to mislead or deceive. So they're fairly heavy words, as you can see. So a person could be a company or a natural person. Trade or commerce is fairly self-explanatory. Now, misleading or deceptive conduct doesn't have to be active conduct. It can manifest itself in ads, packaging, statements by sales staff, promises, opinions, predictions, which have no reasonable basis. So it's the actual effect rather than the intention. So it picks up innocent misleading or deceptive conduct, if I can call it innocent. And also silence can be misleading or deceptive if you omit something. It does not include what you might call puffery, something like, we sell the best steaks in the world, on the basis that no reasonable person would take such statements seriously. But I don't suggest that people get into that territory, because somebody might want to push that boundary and say, yes, they were.
It's quite clearly the best
They were
steaks in the
misleading.
world.
Yes, that's why they travelled halfway across the world.
Yes, puffery. That's an interesting word, puffery. I haven't heard that before.
Yes.
Can you give us some more examples of misleading representation?
Yes, Section 29 deals with that in more detail. False or misleading representations that goods are of a particular standard or quality, or services are a particular standard or quality, that the goods are new, or false or misleading representation about the prices. So it's important to get the pricing right and not just quote a price that gets people in and then hit them with other prices.
It's so easy to be false or misleading in terms of representations without meaning to. Just look at this list that you can see on your screen right now. That list continues on if you go to the next slide.
Yes, false or misleading representations about the availability of repairs or spare parts, about the origin or manufacture of the goods, about the need for them, about the existence of any warranty or right or remedy, or concerning a requirement to pay for something that is in fact required, such as a supplementary warranty, when you might also, when the warranty might be a mandatory automatic warranty.
Right, so what are the liabilities for a company or person who engages in misleading or deceptive conduct?
Well, Daniel, the liabilities could be payment of damages to the aggrieved consumer, or fines of up to $220,000 for individuals, or $1.1 million for companies. What we call equitable remedies, such as restitution or an injunction, or importantly, disqualification from somebody from managing a company.
Yeah, right. So big penalties indeed for both the organisation and the individual.
Yes.
I mean, earlier on I was talking about how knowing this can really help you not give away more than you need to, but this kind of stuff just puts into perspective the really big importance and the business risk that's involved.
Getting it right, yes.
I mean, we see some of the biggest names in the news over the last couple of weeks make
Yes.
headlines for all the wrong reasons.
Exactly.
And, you know, we're not trying to be fearmongers here.
It applies to very broad conduct. I think we need to emphasise that. It says trade or commerce, so it can apply to any sort of business activity can be covered by misleading or deceptive conduct.
Yeah, that's right.
Yeah.
Lots of business risk there to be covering. Scary stuff indeed. All right, on to the last topic. Douglas, let's talk about unconscionable conduct.
Yeah, so there are provisions in the Australian consumer law prohibiting unconscionable conduct. And that, similar to misleading or deceptive conduct, it applies to a broad range of transactions in trade or commerce, not just consumer transactions as we discussed before. So what is unconscionable conduct? Well, it is conduct that is against good conscience. It is harsh or oppressive. And that's judged by the standards of the common law, so decisions made by judges. I can give you some examples in cases.
Yeah, sure.
There was a matter about 20, 25 years ago, a High Court case, the Commercial Bank of Australia in Amadeo. It's a well-known case on unconscionable conduct. In that matter, there were parents of a son. The son was getting a loan from the bank. The parents didn't speak good English. The parents signed the guarantee, but the bank didn't explain to them what a guarantee was. You know, you could lose your house. You're liable for all of your son's debts. The bank also crucially did not disclose to the Amadeos the extent of their son's debts. Their son was well underwater on his loan repayments, and the Amadeos obviously suffered damage because of that. They entered this transaction not being fully informed, not really understanding what they were signing, and it was seen in that case that the bank had a lot of power and a big advantage of the Amadeos, and that was considered unconscionable conduct. A more recent case, which came out this year, was a federal court decision, whereas an organisation called Empower Institute was fined $26.5 million, which is a record fine under the ACL. It was for unconscionable conduct and other things like misleading or deceptive conduct. And you'll see misleading or deceptive conduct and unconscionable conduct cover some of the same ground. In this case, Empower Institute was marketing education courses to Indigenous clients in remote communities, people who in many cases were illiterate or numerate. They were socioeconomically disadvantaged. Their sales staff were offering inducements to their customers, like a free tablet, sign here, and customers who were signing things they didn't understand, taking on large debts, and they weren't really in a position to complete the courses because of their disadvantage. And Empower Institute was basically taking advantage of people. So unconscionable conduct is not just unfair behaviour, it's really sort of immoral stuff that is against good conscience.
Yeah, those are horrible examples, really.
Yeah, it made the news this year, and their education courses particularly being targeted right now for taking advantage of international students and stuff like that.
I was struggling to get the $26.5 million sum.
Yeah, it's a
fine around my head.
Yes.
For this kind of behaviour, which the community would obviously
clearly
agree,
against good conscience.
May well put the business out, company out of business.
Yeah. Absolutely. I mean, ordinary community standards dictates that this is just wrong. You don't need a lawyer to know this.
Yeah, we like to think it doesn't exist, but obviously it does go on. Some factors include the relative bargaining strength of the parties, whether the customer was able to understand the documents, whether there was any undue pressure or influence exerted to get them to sign up, and the extent to which the parties acted in good faith. Now, it's important to bear in mind that these things are always judged in arrears. You know, companies, I think, have got to stand back and try and reflect on what's going on. It's all very well for a court to stand there and pass judgment, but these things are, companies should, as I say, take a step back, take a deep breath, and probably just look at what's going on. Yeah,
absolutely. And if it's that simple, really, it shouldn't be that hard to not breach these.
That's right. As I say, it's fairly outrageous conduct, and you would think, well, why would any company engage in it? Now, as ever, there are no black and white in these areas. What the company may think is acceptable may be judged to be unacceptable. So that's why it's important for a good business to stand back and review what's going on.
Yes, and it's particularly interesting because we're living in a post-Royal Commission world where, regardless of the sectors where all these Royal Commissions are happening in, the focus now more than ever is on good corporate behaviour.
Yeah.
Yes.
Regulation, legislation,
absolutely. All part of good corporate governance, which involves standing back and considering what's going on.
Yes.
So flowing on from that, we recommend to companies they train their staff on appropriate and lawful sales tactics, consider the characteristics and vulnerabilities of their customer base, You know, if you've got a non-English speaking background, don't use complicated English jargon. Try and use plain English, or better still, communicate to the people in their own language. You know, get a translator. If it's big enough, you know, recommend that they get independent advice before they sign. Make sure that any important terms are disclosed. And you know, as part of that process, the company may want an outsider, such as a lawyer or somebody else, to actually review their documents, practices and procedures, and just give it that, you know, that fresh eye to make sure that an outsider thinks that it's okay.
Yes. Well, lots to think about there, particularly in terms of the whole unconscionable conduct. But that brings us to the end of the presentation. Gee, we packed in a whole lot in a short period of time.
Thanks, Daniel.
I didn't think we were going to get through this quickly, but there we are. And that does bring us to the Q&A segment of today's webinar. If you've got a question for Phil or for Douglas, do let us know. Get in touch by clicking the dark blue hand icon. That's in the top right-hand corner of your screen. And if we run out of time on today's presentation, and we probably won't because it's 11:36, we'll make sure we get back to you offline at any rate. So let's take a look at the trusty old iPad. We've got a few questions coming through.
Right.
We've got an interesting question from Luciano. I'm assuming that's how you pronounce it, if it's Italian. It might be Luciano, I'm sorry if it is. But he's asking, what is the date this law is effective from, and is it retrospective or only prospective?
The new ACL from memory came in about 2010 years.
Yeah.
So it's been around a while. Yeah.
Been around for a while. Yes. And then some of the additions came in 2016.
Yeah, so I spoke about small business contracts being covered by unfair contract. That only came in 2016.
And it was November too, so almost 3 years from today.
Yeah, and I've actually had quite a lot of cases with clients where I've said, well, doesn't this apply to me? I said, oh, sorry, your contract was in 2015, so it doesn't apply.
Oh,
so that doesn't
there?
apply retrospectively.
Right.
Yeah.
It doesn't. Just doesn't apply.
Just doesn't.
So yeah.
But you don't want to be sort of skating on those dates. You want to try and get it right.
Yeah, because the whole point is doing the right thing, not tipping the...
But I'd also say, back to what Luciano was saying, the Trade Practice Act was in effect before the ACL, so that would have applied to a lot of behaviour that occurred before the ACL.
But it's really the government's willingness and appetite to prosecute people and enforce the law.
Yes, and I like what you're saying before about whether we just define something as void or if it's actually illegal.
Yeah, exactly.
Because that will have a big impact on that.
It will, yes.
Yes. Yeah, thank you for your question, Luciano. And if we didn't answer it in the way you wanted to, maybe send us another follow-up question and let us know which particular law you might have been referring to. We've got a question that's coming through from James, and he's asking, what are the personal liabilities of directors under the ACL? Phil, I might throw this one to you.
Yeah, that's where a director is knowingly involved in the contravention. Now, knowingly is pretty obvious, and in a small company, a director would know what's going on. But in a larger organisation, director may not have his hands on the wheel and may not know what's going on. So, as ever, it's important for directors and people involved in the management of the business to be very hands-on and know what's going on in the company.
Right. So it's about
and take steps to alter conduct if it's unacceptable.
Being knowingly concerned, I suppose.
Yes.
And penalties, I mean, a director can be disqualified from managing a company if they're in breach of the misleading or deceptive conduct and unconscionable conduct provisions, if they're knowingly concerned, as Phil said. So they can have damages, fines against their personal assets. So there are significant liabilities for a director under the ACL.
Yes, which is probably what explains all the directors saying, oh, I knew nothing of this.
Exactly.
As soon as there's some kind of commission or inquiry.
I'll put my house in my wife's name, yes.
That old chestnut. Yes, thank you for your question there, James. And again, let us know if you've got a follow-up to that one. Raylene's got a question here for us. What if I sell second-hand goods? Am I still liable under the ACL? Doug, I might throw this one to you.
Yes, you are. So, for example, I spoke before about the guarantee of acceptable quality and free from defects. That still applies to second-hand goods, but it'll be taken into account the age and the price of the goods. If you're selling a dress for $10 that's used, it wouldn't be expected to have the same quality as a dress in Myer for $200. Also, if a seller misrepresents that, say, for example, a car is a new car when it's a used car, that would be a misleading representation, as Phil discussed before. So, yes, it does apply to you if you're a second-hand seller of goods.
That's actually a really good question. I didn't even think about that. Thank you very much for that, Raylene. Phil, I've just got a question that came through from Thomas, and it's pretty much what we were talking about before. Can I be liable for the actions of my staff members?
Well, the company is primarily liable because it's the company that would employ them. Yes, but once again, if the director is knowingly involved, yes. It comes back to this issue of knowing what's going on and what... It's probably easier to control your employees than your sales agents. So it says that if you have agents that are not employees of the company, such as contractors or other companies, that you need to work with them to get it right. You can't just assume that they've got their own governance and they're doing the right thing by you. So bottom line, train your staff and communicate with your agents or third parties about what's going on.
Yes, excellent. Thank you for your question there, Thomas. And we've got another question here from Lisa. And Lisa is asking, what if the manufacturer is really at fault? What actions can a supplier take against the manufacturer? Doug, I think you were talking about that before.
Yeah, so important to emphasise the supplier is the one responsible for offering remedies under the Australian consumer law if there's a consumer guarantee being breached. The only exception to that is there's one of those guarantees for goods that only applies to the manufacturer, and that is availability of spare parts and repairs. But for all other consumer guarantees, the supplier is responsible for providing a remedy. Now, a consumer can take action against the manufacturer directly. We spoke of that before. But what can a supplier do if the manufacturer's default causes the supplier to have to compensate a consumer, for example? Well, in the ACL, the supplier has a right of indemnity against the manufacturer, which basically means, yeah, if a supplier has suffered a loss or damage, they can bring an action against the manufacturer to be compensated. But as I said before, a manufacturer doesn't offer remedies like repair or replacement or refund to a consumer. That is the supplier. But the supplier does have recourse against the manufacturer under the ACL.
I see. So that's the difference between the two.
Yeah.
Thank you for that question, Lisa. We've got one other question that's come through. It's from CJ, and CJ is asking, will these slides be available after the seminar to review?
Yes,
well, absolutely. We can confirm that one
yes.
for you. Yes, these slides will be available. In fact, we'll send it to you as an email, CJ, so keep an eye out on your inbox. And that does bring us to the end of the Q&A session and for this program in general today. Philip and Douglas, thank you very much for your time.
Thanks.
Thank you
Thanks,
very much.
Daniel.
Thanks for having us.
Oh, it's been a very informative presentation. And also, you'll see a quick disclaimer come up on your screen today, but please remember, today's webinar is intended as a general guide only. Yeah. We encourage you to contact Matthews Folbigg Lawyers if you'd like specific and tailored legal advice that's right for your business operations. And of course, before you go, please complete the quick 4-question survey to which you'll be redirected shortly. We'd love to hear from you, so do give us your thoughts and your feedback. Today's program will be made available for viewing on demand, and we'll be in touch with you in the coming days with all of those details. Thank you for your company on today's live webinar, and until next time, for us here in the studio, it's goodbye for now.